Welcome back to the Noble Forms video tutorial series. Hi, I'm Richard Noble, the founder of Noble Forms, and I'm making these videos to help you understand how the templates work. In my last video, I showed you how to set up the 3-ring binder that holds all the estate planning documents. I also showed you how to run the explanatory material template. That template produces the cover sheet, the bill, a letter to the clients, and pages to insert after each of the 10-tab dividers in the 3-ring binder. As we left off from that video, I told you that the next video would show you how to create the trust agreement. What you're seeing on the screen now is how we left off the last video. Now I'm going to show you how to create the trust template. Let's get started. The templates are organized in apps, and so far the Olson firm has 2 apps. There's the client interview, and then that's one app. And the second app is the funding, fees, and explanatory material. The apps contain the templates. The first app, the client interview, only has one template. And so if you click review or update, it's going to open the app and show you the questions that are being asked for the client interview. And if you did create documents, a Word document would be created based upon that template. Now, if we click Finish Later, we go back to the home screen. And there's the second app, Funding, Fees, and Explanatory Material. Now, this has more than one app, in contrast to the client interview app. So if I click Review or Update, then when you go to Documents, you can see that these would be the templates that are available with this app. You have the fee agreement, there's the explanatory material, the trust spreadsheet, and the trust funding documents. Well, we had been working on the explanatory material. That's why that one's checked. And again, just to review, if you did create documents, you would get the questions that are asked to actually run that template would be the same for, we're going to talk about trust spreadsheet and trust funding documents later. So let's just click Finish Later to get back to the home screen. But you see, there isn't any template. We haven't seen any template to do the trust. So that's because that template is in one of the other apps. So to look at the other apps, you click Select App, and you see the apps that would be available here. Now, this depends on what your subscription is. If you have estate planning, you're going to see the estate plan and general office practice. But if you had the probate and trust administration, there would be other apps available, like the probate app, the conservatorship app, and the trust administration app, and the client interview for probate. But here, we're just going to take a look at the estate planning app. So if I click that, it's going to add that. And now if you look at documents again, now you see that all these different templates are available under this app. There's the trust, the certification of trust, the will, the power of attorney, and the advance directive. And if you want to run the trust template, you would click and select trust. Now, and it's going to produce, when you're done, it's going to produce a Word document, the trust. Same would be true of certification of trust. A Word document's produced. Will, same thing. Power of attorney, same thing. Advance directive, same thing. Now, you could actually check all of these or more than one, and then when you would create the docs, you'd create more than one. You'd create the documents for the ones that you had checked. I'm going to suggest probably when you're starting out, it might be easier just to do one at a time. Because if you forget to answer something, there's going to be errors in the document, and you're going to have to run it again. And when you have a whole bunch of documents being produced, it just kind of makes it kind of a little bit messy. So it's probably better just to do them one at a time when you're starting out. We're going to do the trust here, so that's when we've checked. So we would go ahead now and do, so if you check a trust, if you scroll down through the interview, the questions that you're asked are just going to be about the trust. Had you checked other apps, had you checked other templates, like the will, then there's going to be questions about the will, but they're not going to be here this right now because we haven't checked them. We can come back later and do that. Now, let's go back to the home screen for John and Jane Jones. Now, you notice that the home screen looks different here than it did when we were just looking at it before, because I've switched to a different view. Actually, I've been adding some other apps to them, but we're not going to talk about them right now. We're going to scroll down. We had the client interview, and we had the funding, fees, and explanatory material. And now we're going to go down and take a look at the estate plan app. That's the one we just added. So if I click review and update, it's going to build the app. And then you go to documents and you see here are the various templates that we can run inside this app. And we've checked trust because that's the document we're going to assemble now. Just going back up here, take a look at married client type. This is a married couple, and in the documents we have checked trust. The question is asked, who are the documents for? And I've gone ahead and filled in most of these, but I'm going to go back and review them and show you how it works. So here you would want to have John and Jane. Now you could just produce a trust for Jane or for John, but we're going to pick John and Jane because this is a joint trust we're going to create. And then it says, so we picked joint trust. We could have two trusts. This is how, if you wanted to have a two trust plan, here in this question, you'd pick John and Jane, a separate trust for John and Jane, and then it's going to produce two trust agreements. But in this one, it's just a joint trust. It's a new trust. You see here, if you were running this app, this template, the trust template, you've got some options. You can create a new trust, which is what we're going to do here. But you could also do a restatement. So if the client already had a trust and you're just going to do a restatement, you'd select restatement. Similarly, if the client already has a trust and they want to do an amendment, here you'd select an amendment to do an amendment. But we're doing a new trust, so we pick new trust. This question about execution information just would allow you to have different dates on the different documents, like the power of attorney could have one date, the will could have one date, the trust, usually they're all on the same date, usually. Usually these documents are all signed at the office at the same time. So the typical answer to this question would be no. Now on client information, this is information that we've already added. We've already gone, when we did the client interview and when we did the explanatory material, these topics were already addressed. Same with the children, same with other important people. This is information that's already into the database. But this is new in disinherited persons, and you could have a disinherited person add people here, but in this case, they don't have any disinherited people. Now, the people, if you're going to click on here, you have to, the people that you would enter here have to be in other important people, or they won't be in the drop-down list. Because you get a list like this of the people. This is drawn from other important people. So we're going to have we'll say no people disinherited in this trust. Then trust general information. Well, it's a revocable trust. It could be irrevocable because you can produce a life insurance trust with this template as well, but this is a revocable trust. Asset schedule. The typical answer is no. You could have a joint trust where you could have a schedule showing a husband's property, wife's property, and joint property. It's possible to do that, and some people do with a joint trust, but typically I would not do that. I would say no. If I were going to have separate property, then I'd go do a two-trust plan and have just the husband's property in the husband's trust and the wife's property in the wife's trust. And you can have, in those two trust plans, each trust can own half of an asset with the other spouse as well. Special needs. Well, typically I would say yes, put this in just in case maybe you don't have any problem at all here with special needs with the current beneficiaries, but you could possibly in the future, say with grandchildren, people that you don't even know about, they could have special needs, and it's helpful to have special needs provisions in the trust just in case the trustee has to set up a trust for a beneficiary that has special needs to avoid having them lose their government benefits. trustee designations. Well, here, so this is a joint trust. Both John and Jane are co-trustees. Here's how you fill the co-trustees in. So first you would put John, and then you'd answer the question, or add one or more co-fiduciaries. And for with a joint trust with two trustees, you'd say yes, and then you would pick Jane from the drop-down list. I mean, it's feasible to have more than two co-trustees, but typically there's only two. The next question would be the successors. So once you've set up John and Jane as co-trustees, you go in and you just keep picking who's going to be the next in line. And again, it could be first successor trustees, but typically it's not. So in this case, Robert, then Sandra. Trustee additional information. Well, these are some questions that, these are options that are available. You could have a successor be allowed to select a corporate trustee. An attorney sometimes does serve as trustee, and if that's the case, you'd answer yes, and there's special language inserted in the trustee powers provisions about attorney fees and how they're calculated, how the trustee fees calculated if an attorney is serving as a trustee. You can have a provision to allow an acting trustee to appoint one or more persons to serve as a co-trustee or successor. The question about compensation, there's some options. Reasonable is the typical one. Drug testing, well, you can take a look at this. It's a pretty draconian measure, but if somebody really is insistent on that, you could add that and edit it if you wanted to. Special trustee provisions. Yes, this is something you're going to probably want to add because it would allow a neutral party to act like as a trust protector to make modifications to certain portions of the trust agreement even after the death of the settlers. This would be for instance, to correct a trust agreement for changes in the trust estate tax laws without having to go to court and ask a probate judge to do that. Next, there are specific distributions, and here you can put in as many as you want. Typically, most people seem to say no, but I just put this in yes to illustrate how it would work. A gift of cash. You can do all different kinds of gifts. The gifts could be cash, or it could be real estate, stock, other property, charitable or non. It depends. So to people, it'd be non-charitable. You have to, or a charity, you put charitable. And then you talk about who's going to get it and under what conditions they are going to get the gift. So here you could have John Jones, or not John, that's the husband. That's wrong. We're going to have Robert Jones, say to the brother. And what happens if the beneficiary is deceased? Well, the gift can lapse or go to descendants, or you can write custom language. Tangible personal property, in this case, it's going to go to children. There's several options. You can say anything you want here. And one of the questions is whether or not they're going to receive the tangible personal property free of the estate tax. And typically the answer would be yes to that. Lifetime distributions. Well, this would be if a settler is incapacitated, is the trustee authorized to make distributions to the descendants? Well, that typically the answer would be no, but if they have small children, then the answer would be yes. And then there's an option here in how the support is characterized if a settler becomes incapacitated. There's a standard provisions, but then there's another detailed one which goes into great detail about how the settler wants to have the very best care. And of course, all these things can be edited. So standard is typical. The next topic is distributions upon the death of the first spouse. And the first question is whether or not the residue is going to be distributed to the surviving spouse. Now, the residue we're talking about here is the 1/2 of the trust assets that's owned by the spouse who died first. And the answer to that question in a joint trust typically is going to be yes. If some other distribution were contemplated, the parties would probably have utilized a two-trust plan rather than a joint trust plan. The next question is whether or not the distribution of the residue, and this is the 1/2 of the spouse who died first, is going to take into account planning for the U.S. and Oregon estate taxes. And typically, the answer is going to be yes. And so there are two different options that you can pick. when you are planning for the estate tax here in this trust template. The question is whether the spouse is going to the surviving spouse is going to disclaim, and that would be where the half of the spouse who died first is offered to the survivor, and then the surviving spouse would discuss this with their attorney and decide whether it made sense to disclaim all or part of the half of the spouse who died first. And that would be a disclaimer. And if the decision is made to disclaim, then the disclaimed amount is then distributed, instead of to the surviving spouse, it's distributed to a type of exemption or trust called a disclaimer trust. And the disclaimer trust, then in the trust agreement, there'd be provisions for how that trust would be administered. And typically, the surviving spouse would be the trustee of that spouse, and the surviving spouse would be the beneficiary of that trust, of the disclaimer trust, for the lifetime of the surviving spouse. And then at death, what's left in the disclaimer trust would be distributed to typically the children or to the residuary beneficiaries. It's optional. And typically what would go into like the disclaimer trust would be you'd put up to like the maximum federal amount. The part over 1 million, which is the Oregon limit on what can pass to a non-spouse without paying estate tax, would go into the disclaimer trust. And if there were more that were going to be distributed to the disclaimer trust, the agreement provides that the trustee, on filing the Oregon estate tax return, can make what's called a Q-tip election. And the part over 1 million would be put into another type of exemption trust called the Q-tip trust. It would have its own tax ID number. It would be administered separately. And because it meets the requirement of Q-tip, it would be deemed to be distributed to the surviving spouse at the death of the first spouse, and it would not be subject to tax at the death of the first spouse, but the tax would be deferred until the death of the second spouse, when the Q-tip portion would be part of the taxable estate of the surviving spouse. So that'd be the disclaimer trust. It's optional. Now, just to make this discussion about the disclaimer trust a little bit more understandable, I've produced the joint trust agreement, and I'm just going to review the part of it that pertains to the disclaimer trust, or what happens at the death of the first spouse. So it says in Article 7, upon the death of a settlor, there's to be a division of the trust into two parts. There's the survivor's share and the decedent's share. And there's a formula here if you were to use the different schedules, if you had his property, her property, and joint property, but where you just have everything's 50-50, basically the shares are just 1/2. So it says here in Article 7.4 that the decedent's share shall be applied as provided in Article 8, and the survivor's share, their 1/2, shall be distributed to the survivor's trust to be administered and distributed as provided in Article 9. Well, let's take a look at Article 8. So Article 8 talks about what the duty of the trustee is at the death of the first spouse. Pay personal property, distribute personal property, payment of taxes and expenses, make specific distributions. And then it gets down to the balance. So once those things are made, then the balance, this is after the payment of the distributions and obligations described in the above paragraphs, the balance shall be distributed to the survivor's trust, in other words, to the survivor, and applied and distributed as provided in Article 9, which is, Article 9 talks about the survivor's trust. But it says, provided, however, that if the surviving settlor disclaims all or any part of said settlor's interest in the balance of the decedent's share, then the disclaimed portion shall be distributed to another trust referred to as the disclaimer trust and applied pursuant to paragraph 8.8. And paragraph 8.8 talks about the disclaimer trust. It's irrevocable, the name can make distributions to the surviving spouse. The surviving spouse can be the trustee. It talks about the division of the disclaimer trust to take into account the fact that in Oregon you can only distribute $1 million to a person that you're not married to, and provides for an Oregon Q-tip election here. So you could have, and that would be, if that election is made on the estate tax return, then that transfer is not subject to the Oregon estate tax at the death of the first spouse, but is deemed to be part of the survivor's taxable estate in Oregon at the death of the second spouse. And so there's a provision here for the Q-tip. And in both cases, whether a Q-tip is elected or not, upon the death of the surviving spouse, the balance of the disclaimer trust shall be applied as provided in Article 10. Well, Article 10 is the final distributions to the kids. Similarly, under the Oregon Q-tip, if part of it's Q-tipped at the death of the surviving settler, the balance is applied as provided in Article 10. Now, if you pick pecuniary credit shelter instead of disclaimer, then the trust mandates that the maximum federal amount be put into an exemption trust. It's not the surviving spouse can't say yes or no. And typically in those types of cases, you would maybe have a different trustee than the spouse. The spouse could be a trustee, but oftentimes not. Maybe a financial institution would be the trustee. Now let's take a look at the other option, other than using a disclaimer, where you mandate the funding of a credit shelter trust. Here, so we're still looking at the interview, and you can see at this point, we're going to do pecuniary credit shelter rather than disclaimer. And I think the best way to explain this, rather than just talk about it here, is to actually show you what the trust agreement looks like when you pick pecuniary credit shelter. So let's take a look at that. So it's got the same division, just like in Article 7, just like we had when we used the disclaimer approach. At the death of the first spouse, the trust is divided into two shares, the decedent share and the survivor's share. And again, you're pointed to Article 8 to see what happens to the half of the spouse who died first. So let's take a look at Article 8. And in many ways, it's kind of similar to what happens with a disclaimer. The trustee is directed to distribute personal property. The trustee is directed to pay taxes and expenses. The trustee is directed to make specific gifts. And then the balance. So then at that point, what's left after the payment of those distributions? The trustee is directed to divide the balance of the decedent share into two parts. One is called the marital deduction share, and the other is the non-marital deduction share. Well, the non-marital deduction share would be the part that's going to go into the exemption trust. The marital deduction share would be the share that's going to get the marital deduction. And so the instruction is, with respect to the exemption trust or the non-marital deduction share, shall consist of the largest pecuniary amount of the decedent share needed that may pass free of federal estate tax. So that would be like $13.6 million. Now, most people really don't have that big of an estate. Everything, if you were going to mandate that the survivor's half be put into an exemption trust, you'd find that really everything is going to go into the non-marital deduction share. It goes on to say that the marital deduction share, the other share, is determined by, it's the balance of the decedent share that's not included in the exemption trust. Well, in most cases, that would be zero because everything is going to go into the exemption trust. So first, the trust talks about if the marital deduction share were were funded, which, like I say, probably it's not going to be funded. Basically, it talks about how you would fund that. That could be either a trust, or it could be a marital trust, or it could go basic to the survivor's trust. In this case, we said it's going to go to the marital trust. So it talks about here in 8.7 how the marital trust would be administered. But basically, what's most important would be 8.8, because that talks about the non-marital deduction share. And that's the rules for how the exemption trust would be administered. And either trust, at the death of the survivor, everything is going to go under Article to the final distributions. And just like we had in the case of the disclaimer trust, in this exemption trust, it could be part of it could be Q-tipped as well, the part over $1 million. But at the end of the day, everything that's left in those trusts is going to go under the final distributions. It's going to go to the kids. Now, we've spent a lot of time talking about the administration of the half of the spouse who died first. But let's now go take a look at what the trust provides for the administration of the surviving spouse's half. And remember that when we talked about distribution upon the death of the first spouse, the question was asked whether the residue would be distributed to the surviving spouse, and the answer was yes. And recall that when we were looking at the trust agreement, that I'm going to bring it back up here again. Article 7 talks about the division of the trust estate into two shares, the survivor's share and the decedent's share. And here in Article 7.4 says that you are to take a look at Article 9, the survivor's share shall be distributed to the survivor's trust to be administered and distributed as provided in Article 9. We were looking at Article 8 for the share of the spouse who died first. Let's take a look at Article 9 and see what it says. So Article 9, the survivor's trust, states that with respect to the name, called it the survivor's trust. Remember, we have a joint trust, and now it's at the death of the first spouse, we're talking about what happens. Well, the half of the spouse who survives now is called the survivor's trust. But it says here, while referred to in the following parts as the survivor's trust, this trust is in fact the continuation of the settler's living trust and shall continue to be known publicly by the same living trust name stated above in Article 1. So the assets that were titled in the name of the joint trust, you don't have to retitle them at the death of the first spouse, like into a trust called the survivor's trust. You can continue to it's still called the joint trust, the name it was given in Article 1. And this is the survivor's trust is a revocable trust. It's just a continuation of the joint trust. The surviving settler has all the rights to revoke, amend, withdraw assets. The tax ID number, if this husband has died first, and if the husband's tax ID was used, his social was used as the tax ID for assets retitled in the name of the trust, then the surviving spouse, the wife, is going to have to notify the financial institutions that now her social will be the tax ID. She still has all the rights. She can do whatever she wants with her trust. It's just like it was with the joint trust. But then that's Article 9.1 during her lifetime. But then at her death, 9.2 provides for the instructions to the trustee. And it's very similar to what happened at the death of the first spouse. The trustees told to make specific distributions, if any, to pay taxes and expenses, to distribute personal property. And then when all that is done, what's left, that's the residue of the survivor's trust. And the trustee is directed to distribute the residue according to Article 10, which would be distribution to the kids. So at the end of the day, when both spouses have died, everything, whether it's if there's a disclaimer trust at the death of the first spouse trust or an exemption trust at the death of the first spouse, whatever's left is going to go on to the kids. And the survivor's trust, What's in that at the death of the survivor is going to go to the children as well. Now I'd like to move on and talk about final distributions. Noble Forms allows almost unlimited types of final distributions. You can tailor to almost any situation. First off, you're asked who are the beneficiaries, and here are some options. Basically, it could be the children on the basis of representation equally, and you would use this in situations where there are, say, minor children, where their distribution will be held in trust for a certain time period. But the trust that's created has to be the same. So if you had a situation where you had a minor child, like the one we're going to do here in a minute, where say one of the children, minor children, is a disabled person and needs a special needs trust for a lifetime, you can't say equal to children because the type of distribution isn't equal. Then you can have a single individual or charity. Then you can have multiple named individuals equally, and that's the one we're going to use here. You can, inside of the equal distribution, you can have different types of distributions, like one in trust, not in trust, etc. And then you have multiple named individuals or charities with unequal shares, where you have by percentage, or you could have the same thing with fractions, where they're unequal. And sometimes, if people have odd distributions, you can't really do it by percent. You need to do fractional. So in this case, we're going to pick multiple named individuals equally. And you can also have a plural class description, like nieces or nephews. You would just type it in here. In this case, we're going to do multiple named individuals equally. And the individuals we're talking about are the two children, William and Phoebe. Now for William, if you click on it, and this would be William, the son. He's not married. And you can put down here how the share is going to be distributed. It can be distributed outright, in a specific trust, which terminates at a certain age, lifetime trust, or a special needs trust. And then the question is asked, if you pick like a specific trust, which we're going to pick here, then the question is asked, well, what if he were to die before the settlor? Where would his half go? Well, it could go, you have different options. It could go to William's descendants, or it could go to his descendants, then the settlor's descendants, or it could go to just the settlor's descendants, or to a named charity or individual, or to custom. So you see it's pretty flexible here. If he were to die before the second settlor. Now, if it's held in a trust, it terminates at a specific age. What would happen if he died before that stated age when his trust is going to terminate? So again, you have these other options. Well, it could go to his descendants or to his descendants, but if none, to the settlor's descendants, or it could go to the settlor's descendants, or to a charity, or to custom. You can write anything you want. So the question here is he's going to be held in trust. And then you can say, well, what about distributions? It could be all at one age, like say at 30, or you can pick this one, or you can do a custom. So if you want to do custom, I picked this one. Let's make it custom. So say they want to do custom. Say you want to do, you have to scroll down a little bit. Sometimes these things you can't, be careful. I wonder, where was the next question? Well, you have to scroll down a little bit here. And you can have custom. So you'd say at this point, you click and you go, well, say at age 25, we're going to do 1/3. So 1/3. And then add another, say 30. Say at age 30, we're going to do 1/2. Well, let's do 27. 27, 1/2 of the balance. And then the final one would be at age 30. And that would be the rest. So that's 1/1. And income, discretionary. The trustee isn't required to do anything. Now, these principal distributions are not discretionary. They have to be made at the age is stated. Now, you don't have to do that, but you can. You could just say, well, everything at age 30, say. And then should the distributions of principal be expanded to include the purchase of a home, wedding, business, and typically the answer would be yes. Power of appointment, well, if he were to die before he reached age, I think we said age 30 up here, say he died at 27 and there was still a balance, then he could, if you give him a limited power of appointment, he could in his will appoint somebody to receive his, what's left of the balance of his trust, but it's limited, like to his descendants or to his spouse, the power in the document that's created. And then will the trustee be different? And the answer, most of the time is no, just be the trustee that you've picked to be the trustee of the main trust. Then you'd click OK. Now for Phoebe, just for example here, say, so she's not married, and let's say her share, say special needs. She's handicapped, and we know she's going to be on government assistance in the future. So at that point, if she's the subject of retirement benefits, then the question would be, who would be successor beneficiary? And so it would be, say the other child. If the trust isn't going to receive retirement benefits, then the question be, what if she dies before she receives, at her death, who gets what's left of her trust? And no power of appointment. And then the question is she a beneficiary or not? And there's some special rules that go into play. If her trust, her special needs trust, is a beneficiary of a retirement account, there's some very specific rules that apply to how that has to be structured. And then you're allowed to, if you want to describe why a particular distribution plan is being used, you can answer it here. You could put in special distribution provisions, such as allowing a party to live in a home for a time. And then there's contingent beneficiary. So this would be probably if you had 30 for the son, maybe the 30 would be the age for final distribution. This would be if, say, William died but had children and it went to grandchildren who were under 30, the trust provides that their share would be held in trust, and the trust is described in the trust agreement for them until they reach the age of 30. And then the question becomes, what if everybody has died? Both of their children have died, and there's no grandchildren. Where is the estate going? And so there's a bunch of options here. You need to have something that is definitely going to exist so you don't have a escheat to the state of Oregon if you run out of beneficiaries. And then there's a question of who's survivorship information, who's presumed to die if there is a simultaneous death, and then the execution information. And that would be basically all the questions that you would have for doing the joint trust. In a minute here, I'm going to bring up an example of what the trust looks like to kind of explain the final distributions. I've saved the trust agreement here, and I've got it up on the screen. And I kind of want to go through it with you just for a little bit and kind of highlight some of the topics we've been discussing here to date in this video. One thing to point out is that when you do start to look at the document in Word, you want to make sure that you do see the navigation panel. If you don't see it, you have to go up to View and make sure that navigation pane is checked. If it's not checked, you won't see it. So you click navigation pane. And the reason why you do that is because you want to kind of search and make sure you haven't forgotten to answer any questions. To do that, you take the left bracket and type it in the navigation window. And it says no matches. So that means you've answered all the questions. If you hadn't, there'd be the name of the variable that you failed to answer the question and surrounded by brackets. So you have to go back and rerun the template and answer the question. The other thing you might want to check too, the word error. Sometimes if there's a problem with the template, and we try and proof all these, but sometimes, people will do a particular fact situation and something might come up as an error that we haven't anticipated. And if that happens, just be sure and notify us, because we can fix that. So there's no errors and there's no unanswered questions here. And the way this document works, there is a table of contents at the very beginning, that just a regular table of contents. And the other nice thing about having the navigation pane open is that in Word, you can actually navigate through your Word document by just clicking on these on the panel here on the left-hand side. And you see these actually expand and contract. You can collapse, right mouse click, collapse everything, and then just kind of navigate. So if you click, go to name of the trust, you'll see how it kind of starts out. So this is the Revocable Living Trust Agreement, the date of the signing between John and Jane as the settlers and John and Jane as the co-trustees. And this, so it talks about the agreements made on November, 15th day of November between John and Jane as husband and wife as the settlers, and John and Jane as co-trustees. Got the name of the trust, the family, etc. Now, if you go through Article 3 talks about the different types of property that can be put into the trust. Article 4 talks about amendment and revocation. Article 5 talks about trustee succession. The original trustees are John and Jane, but if neither can serve, then Robert would serve, and then if Robert couldn't serve, Sandra would serve. There's all the trustee powers set out here and various information about the trustees. Here's a co-trustees. It says that a co-trustee may bind the trust. Just one co-trustee can bind the trust with respect to third parties, and that's always important when you're approaching a financial institution. If they're co-trustees, the banks often want to know, well, do both co-trustees have to sign checks? The answer is no. Article 6 talks about administration during the lifetime of the settlers, and provides here in Article 6.2 the standard for the successor trustee to care for the incapacitated settlor. Article 7 now talks about the death of a settlor. Mind you, this is a joint trust. There's two settlers. There's two lives in questions. And we've looked at this before. It talks about the division into two shares, survivor's share and decedent's share. The decedent's share is discussed in Article 8, which we've looked at already. And then in this particular version of the trust, it's for a disclaimer. So it would go to, at this point here, after all the taxes are paid and the personal property is distributed and the specific gifts are made by the trustee out of the half of the spouse who died first, then there's this provision here that balance is then offered to the survivor who has the right to disclaim. And if disclaimed, Article 8.7 talks about how the disclaimer trust is administered. At the death of the surviving spouse, everything in the disclaimer goes under Article 10. Article 10 is the final distributions, the distribution to the two children. There's a Q-tip provision in here that if you Q-tip part of the disclaimer trust, the part over $1 million, it too, upon death, the balance goes to Article 10. Article 9 talks about the survivor's trust, and we've already discussed this a little bit, where during the remaining life of the survivor, that a survivor's trust is basically just a continuation of the joint trust, and they have all the rights that go along with to revoke and amend and withdraw assets, to select the trustee. Nothing's changed. And then 9.2 discusses, and the instructions are to the trustee what to do upon the death of the surviving settlor. Just the specific distributions are to be made, personal property distributed, taxes are to be paid. The residue goes under Article 10. Now, Article 10 is what we were just talking about here recently, just about the final distributions to the two children. And it discusses in Article 10, it just, for instance, William, it says that William's share, and these are equal shares, is going to be held in continuing trust subject to Article 11. And then see over here, there's a specific article, Article 11, that talks about William's trust. The trust for Phoebe is governed by Article 12. This is a continuing special needs trust. So if you go and look at Article 11, this talks about the mandatory distributions, at the different, at 25, 27, and 30. Power of appointment, we talked about. Distribution if he dies prior to receiving full distribution. The trust for Phoebe is a special needs trust. Then there's a trust for contingent beneficiaries. This would be perhaps grandchildren, say they're contingent upon, say, William not surviving. And if they are under the stated age here of 30 years, then their share would be held in continuing trust. There is also a provision for a special needs trust. Now, in this case, we do have Phoebe. She's got a special need. But this would be, if you would apply to other beneficiaries who are at the time of distribution receiving government benefits. Contingent beneficiaries would be one half to the wife's husband's heirs under the Oregon law of intestate succession and half to the wife's. There's a discussion here in Article 16 about retirement plans. It deals with the recent changes in required minimum distribution rules. And then there's definitions and miscellaneous and provision here at the end for both settlers to sign, both in the capacity of settlor and co-trustee, and there'd be acknowledgement. So that's basically an overview of the trust. We did the joint trust. There's also the possibility of doing individual trust, two trusts, one trust for husband, one trust for wife. Also, there's a possibility of doing an irrevocable insurance trust, which we may talk about in future videos. Thanks very much for watching this rather long video here, but hopefully it gives you an introduction to the trust. And if you have any questions, feel free to contact me either by phone or by email, and we can talk about it more.